Hi, I'm David Kopel, adjunct professor of constitutional law at Denver University Stern College of Law, and also research director of the Independence Institute. My testimony, as with all scholars from Independence Institute or DU, is my own opinion. This bill could be improved by specifying the fee to be charged. There's a lot of concern out there about saying that, well, maybe $10, which is supposedly what it's going to be, is not too bad. But people are well aware of the experience in California where it's been bumped up to $39.50. Now, the limitation that was a good limitation amendment on the House floor on second reading said direct costs only, but even with direct costs, there's lots of creative accounting that can go on, and those, well, at the FASTER bill and school finance show that the ability for creative accounting in the Colorado state government is quite impressive. And there were, for many years, the legislature had the practice of saying, we're just going to, whatever the fee is for anything, we'll say what it is. If we want to change it later, we can. And yes, does that mean that when you want to go from 10 to 12, you've got to have a bill and all this trouble? Yes, it makes it harder. It also reduces a lot of the risks that many worried people are seeing. And I suggest that one of the purposes of the moderate proponents of this bill is not to ramp up the culture war to a scale of 11 on a 1 to 10, but to be reassuring to people and to say that we can take some steps in a moderate way, and even if you don't like them, you don't have to worry that we're going to end up down the slippery slope several years later. There's also the issue of waivers, and you can have a long list of things that involve some relation to constitutional rights, where sometimes fees are charged if you want to have a parade down Colfax or whatever. But we also have a tradition, at least in this state and nationally, of waivers for people who are indigents. So, for example, if you want to file an appeal in a civil case, can the government charge you a fee for doing that? Yes, but can they also have the choice to say, if you're indigent, we will waive the appeals fee in your civil case? They can choose to do that. And so I would urge you to find some level, whether it's Medicaid eligibility or food stamps or federal poverty line, but some easily defined thing, and say that this doesn't apply when you go below for persons below this income level. Because when you're talking about somebody buying a $550 handgun in a store, is $20 extra that burdensome? No, it's not. But for a poor person who really can't afford anything other than the $90 for the gun she's buying from a pawn shop, that really can be a significant burden. And this is a fundamental constitutional right. And so it would be wise to at least exercise the choice to not excessively burden the exercise of the right by indigent people with fees. Thank you.
Thank you. Any questions? No more questions for you, sir. He doesn't. Did you hear me?
Thank you, Madam Chair.
Senator Crowder.
Your last sentence is what interests me. Fundamental right.
Yeah.
Would it be feasible to say that, like, let's say the gentleman next to you who is a veteran who earned that right for this Second Amendment, the price has already been paid?
Mr. Kopel.
It's within legislative discretion to do so, I believe, yes.
Thank you.
Any other questions? I have a question. So there's been a lot of testimony both on this bill and on the previous bill talking about the constitutional right. And certainly we were charging a fee prior to 1999, and I'm not aware that that was ever challenged to charge the fee that the state was asking for background checks. As with your tremendous background and reputation, can you address the constitutionality of charging a fee?
Well, as a practical matter, in 1994 to 99, the Supreme Court had maintained its reticence, decades-long reticence on the Second Amendment, so there was still a continuing argument over what does the right mean at all. Is it a right that's only for state governments to have militias? Is it a collective right, which means everybody has it but nobody really does? Or is it a normal individual right? And in that kind of context, only a foolish lawyer would have brought a case involving a fairly low fee on something where you haven't even established the fundamental groundwork. And that's why DC versus Heller was something that was clearly about the core of the right, the ability to use a firearm in your home and to own a handgun. And there were not challenges on peripheral issues. I think there was talk in the gun owning community that this is like a poll tax, it's a bad idea. But there was clearly not the appropriate time for any sane lawyer to bring a case on that. And the analogy is made to poll taxes, and poll taxes were constitutional until they were outlawed. But there is, at the federal level, and then the Supreme Court got rid of them at the state level as well. I think the people raising this concern have a legitimate point. I haven't really studied it in enough detail to have a firm opinion, and unlike some law professors, I try not to have an opinion on everything, even when I don't know for sure what the law is. I think the poll tax argument is not a completely inappropriate one, but at the same time, I'm not sure that it's a winner either, at least in a court test kind of situation.
Thank you. Senator Jones.
Thank you, Madam Chair. I must say you sounded like an academician right there. So,
Well,
keeping the options open.
Well, yes. Yeah, sometimes it reduces how much I get on cable TV that I don't have a firm answer even when I don't know.
Thank you.